Nicholas Frey, welcome to Digital Markets Research Hub. I should
Thank
start
you.
this conversation by saying that one of the advantages of working at the University of Exeter is that we have critical mass of people who are genuinely interested and truly passionate about competition law. And while co-teaching competition law module, I was really impressed by attending your visiting guest lecture organized by Professor Mikhail Danov from Exeter. You delivered to our big cohort of competition students, focusing on private enforcement and beyond. I'm also happy to know that you are affiliated with the University of Exeter. So while being in charge of private enforcement team in one of the leading law firms. I also will be talking to you in your kind of academic capacity. So we will try to examine the mechanics of the process, of this rapidly evolving process where the stakes are increasingly higher and higher. And it's super interesting from purely juristic perspective, but also given this kind of broader societal impact with the focus on digital markets and beyond. My first question is an invitation maybe to remind to the listeners the main phases of your career.
Um, thanks very much, and great to chat to you. I think I didn't start off in law. I was, as many people at the time, I'm Swedish by origin, so I actually studied Russian both in the Swedish army and then in the military in Sweden, and then came over and studied law in the UK and started at Freshfields in the mid noughties. Obviously, a very different time then, around the time of the financial crisis. Lots of companies struggling, lots of people not getting jobs. So a very different dynamic, I think, from what we've had during the last few years. I've always, I think, had an interest in competition law, also as an international student, and I think found myself drawn to litigation during my training contract as well. And antitrust litigation, or EU litigation, as the team was called pre-Brexit in our firm, felt like the perfect fit to me. I'd say at the start of my career, I was very heavily focused, in particular, on cartel investigations, and that was very much the market at the time, with many leniency and immunity applicants, things like marine hose and the benchmark rate infringement allegations in relation to the banks. There were very few private enforcement competition cases. I still do pure competition work, but now I'd say a significant part of my practice is private enforcement in all its forms. And in particular, I spend a lot of my time doing class actions and global coordination. So the game is certainly very different now and has developed a long time. And we certainly are a much larger team now than when I started off.
And maybe just to visualize the latest phrase, you said that you are a much larger team. I remember again from the lecture, and Mikhail said when we're talking about teams, we imagine like a group of three, five like-minded academics, and we extrapolate this projection to the leading law firms' teams. So when you talk about team, we are talking about much larger cohort.
Yeah, I mean we are, well over 100 people who specialize in mass claims, and I think within that you've got people with particular focus areas as well. Some who are more focused on consumer, and some who are a bit more focused on competition. But even on pure competition specialists, we're over 60 now who have that crossover competence, and others who would fit into that and add other elements like patent litigation or copyrights, as we're seeing in some of the cases now as well. So they're large teams, even just in the UK on a cross-border basis. Obviously, you're talking, several hundred people who work on these type of matters now. So very, very large teams.
And uh, you've been co-creating the regime, let's say, by contributing and being continuously engaged. So it would be very interesting to learn your kind of understanding of the evolution of private enforcement in digital markets and in broader areas as well in the United Kingdom.
Yeah, I mean, as I say, it started off when my career was starting. There was really Provimi and a few other cases, and there wasn't really very much happening. And then you had the first cases in gas insulated switchgear and marine hose, and there was more awareness of bringing claims. But I think that time in Europe, and certainly particular types of Europe, there was still this perception you don't want to be too American and you don't want to sue your friends. It's not the done thing. And I think that has changed, quite significantly over time. And there are a number of different reasons for that. Obviously, a clear acceleration point was when the opt-out regime was introduced, which has led to a number of cases we've been involved in too, the likes of MasterCard, and then the lowering of the certification threshold in the Supreme Court in that case obviously resulted in a whole host of additional claims. But I think accompanied by that, you've seen a growth of funder interest spreads out from the states. You've seen a change in business when people are getting sued and fined, realizing that actually they could recover some monies. So the likes of Deutsche Bahn were forerunners in that space, setting up units essentially to buy up and bring claims and become a profit center. And I think that awareness has just, increasingly flowed at the same time as a lot of these matters and considerations in the digital markets or otherwise have become very much cross-border. And it's not really a lot of the matters I'm doing, it's not just enforcement you're looking at often enforcement at the same time as you're dealing with investigations, maybe in other countries, and you have to take into account those developments. And you may have cases which raise competition issues, but also consumer or fraud or other issues. So it's become a very different situation now. At the same time as tech and awareness, I think, has made it, in addition to AI, has made it much more easy to access information, to prepare your cross-examination of witnesses or experts. And we're closer to an era, I think, of perfect information, with a very low threshold now for bringing claims or raising complaints against companies.
I wanted to ask you a little bit later about this element of really cross-border, cross-jurisdictions, where the development in jurisdiction A may have obvious and much less obvious implications on many other jurisdictions. So it's a very interesting strategy gaming, essentially, which you probably have a secret room with big map where you can somehow put these jigsaw puzzles together. So it would be interesting to learn more. But I wanted to pause here at the evolutionary kind of stage of private enforcement. One would say that a system can be considered as matured when the key players in the system can predict with more or less a considerable amount of accuracy the result of the next major case. I don't know if this a correct benchmark or not, so it would be interesting to learn from you. But if this benchmark is correct, can we say that the private enforcement system in the UK and maybe in other European jurisdictions is mature enough, is predictable enough, or it is still in this phase where each new case adds to the system and it's so volatile and so many factors have to be somehow scrutinized and thematized that it's hard to say that it's predictable in this regard?
I think we're still, part way on a journey. And I think the UK is still more developed than other jurisdictions. I'd say if you look just at Europe for some time now, you've had some courts which have been, incredibly defendant friendly, even some courts where I've brought torpedo actions in the past. And people used to talk about the Italian torpedo, for example. I'd say the Italian courts are now some of the most rapid in the European Union, certainly. And at the same time, you've had a lot of political interference over the years. And I think pressure on courts, even places like France, which I think would have been historically, lower damages jurisdictions, you're seeing a change in direction in some cases there, partly, I think, driven by the damages directive, but also partly driven by imperatives and the fact that I think you're getting a lot more cross-border, cross-judge discussions, and we are seeing, judges in one jurisdiction ask for, information about what judges elsewhere have been doing, and even ask for lists of outcomes in other jurisdictions to help them guide their own thinking. So there's more of that, even when it's not technically binding or has no technical influence on their case. There is that sort of increased exchange, but at the same time, I still think you're finding in a number of these cases in different countries, courts taking different approaches. Obviously, you had that in some of the early interchange fee litigations where you had some different outcomes essentially on the same facts, and I still see that in some of the European countries. But I don't think you'd look at a case now necessarily and say, yep, it's definitely going to be this percentage overcharge. This is the final position on pass on. This is on interest. I mean, I'd like to think I have a fairly good view of where a particular case may end up, but often that involves quite a rigorous assessment of the facts, and so many cases now are standalone and involve not just damages but conduct considerations or interactions with ongoing investigations or decisions which you might be appealing, that it would be difficult for me to say that you're here and you can definitely predict what's going to happen. So I think we're on the road to maturity, but there's still a lot to fight for, which is probably reflected in the very few cases that are actually settling now. For example, in the UK courts, most things are going to trial.
And obviously, this means, among other things, that the expertise generated by the firms which are participating in each of these proceedings is unique and precious. So I'm interested in learning, how do you communicate with your clients? How do they approach you? What do they expect? Do you primarily work on the defense side, or each case you also represent claimants, classes? How the conflict of interest has to be considered as a factor in choosing or accepting the invitation from potential client?
Well, I think every firm, obviously, in every jurisdiction has some slightly different conflicts rules, and we always look to take those into account. So that's a case-by-case assessment. I mean, I'd say generally, personally, I'm defense side, and the complainant work I've done, most of which is slightly below the parapet, has been, heavily focused on abusive dominance. I find it a bit trickier, I think, in the cartel space to see myself acting on both sides. Not impossible, and there are certainly several barristers who do it, but it's, I think, the more often ones before courts essentially arguing two sides of the coin, which is particularly acute in a cartel context. I think it's more difficult to maintain credibility, and so I don't think that exists as much in the abuse phase, but we think very carefully about this, and I think would err towards being on the defense side generally. I mean, client wise, I think the market has shifted. I think some of my clients, tell me every week, how many of my competitors have called them and offered them free advice and things like that. And I think we have, despite not wanting to become more American, and we have become a lot more American, and certainly in the mass claims space, I think, it's important to be quick, accurate, and helpful. And, you have to get in there early if you spot an issue. And I think clients appreciate forewarning. Obviously, there will be cases where you have existing relationships, or you have institutional relationships, or which might affect dynamics. But there are a lot of cases where, you know, we've come in through, you know, spotting an issue and maybe seeing it in a slightly different way from others, and proactively given advice, and then, you know, come in. And then there are some cases where we or other firms come in as, you know, as a second pair of eyes if there's a particularly a big issue. And so there are also cases where we're slightly behind the scenes, but are testing as an additional voice to see what happens. And I think in doing that, you know, you mentioned different types of firms. I mean, we're obviously a global firm. We've benefited, I think, from volume and being in some of the biggest cases like Dieselgate and MasterCard and trucks and a lot of the tech cases. So there is just that benefit, I think, of experience and having developed teams with the minimum of cross-border fiction. And I do think in some of these cases, you're often playing, you know, to quote Big Bang theories, of the three-dimensional chess, where if you're just a litigator, or you're just a competition lawyer, or you're too narrowly focused on your jurisdiction, you will miss something, because actually the game, you know, involves reflecting on how, you know, if you pull a lever in UK litigation, what sort of tremors that will have elsewhere, especially if you're, for example, in a commission appeal process, or you've got claimants who are increasingly active in multiple jurisdictions, you know, bringing parallel cases or book building or equivalent. So that they're all the sorts of things where I think you are in the market seeing clients placing more value on that global coordination piece and that interaction, and ensuring that you're at least looking out for them, because for them, you know, often it's not, say, just damages, it's conduct, and it might not be just money, it may be a whole business model, and that business model isn't just local. Usually it's international, or can have international ramifications. So that lots of factors that feed into, you know, how one approaches and progresses those sort of cases.
And you mentioned the need to be kind of not one-stop shop, but at least to have coherent or broader understanding of what's going on in other countries and on specific issues. In the same kind of mutatis mutandis can be applied probably to the purely legal expertise and its connection with broader political, judicial process or deliberation process is partially political endeavor, particularly when the system is not established yet and when the stakes are so easily politicizable. And indeed, when you talk about industrial policies, they have implications, whatever, in whichever direction you adjudicate, it does have implications on industrial policy in the sector. So is it beyond the interest, the focus? Do you offer your services as narrowly designed for being purely juristic, or it's also a broader legal plus kind of services?
As I say, I'd say 80% of my work now is a broader service, a global piece. You know, tracking, because I do see these as global risk assessments, and often working with boards and others to, you know, identify what's going on and optimal outcomes and optimal strategies. And that might mean sometimes doing something in one jurisdiction which isn't necessarily the best choice in that jurisdiction, but the cost of not doing that is so great elsewhere, where something matters more, that it's worth it. And I think ultimately, you know, lawyers are poor where they focus too much on their own pride and their own case outcomes, rather than the, you know, the overall outcomes for a business. And that for me is always the priority. How am I serving the business in the best way? And sometimes that means, you know, maybe ending up with, you know, running a point or putting forward something which personally is not my favorite, but it feeds into, you know, a broader strategy. And I think, you know, even if you've got rules in different countries about use of foreign law judgments and developments, I mean, people are interested. And so many of these cases now, even after recent UK case law, they're standalone and they refer to judgments and developments in other jurisdictions, and it creates a sort of context, even if it's not binding, and it also creates a Estoppel risk. I can't go in the States and say something and then completely deny it in the UK if it's the same exact factual proposition and same market. And people look out for that, just as they do with the economists. And people can understand, for example, in the US, why you might settle, because you've got the risk of treble damages in cartel cases. But sometimes, to your point, in less developed jurisdictions, there may have been a particular political imperative for an outcome, but unless it's well known or understood in the market, a judgment will just stand as a judgment, and it will have some contextual relevance. And I think we see that increasingly. Judges are people, understandably, and they look to see what their friends in other cultures are doing, and they may then take it with a pinch of salt or interpret it's it gives some sense of reassurance, I suppose.
DMCCA, so we understand the motivation, or we hear at least the rhetorics of why we needed it, and people also see how many changes it brings in terms of the discretion of the CMA. There are least obvious aspects of DMCCA, and one of those least obvious aspects is the implication on private litigation.
Yeah. It's obviously early days for the DMCCA, and there are lots of things to be worked out. And I think clearly in connection with SMS breaches and SMS monitoring, whether there's a breach or not, there'll be documents and information created which could help in due course found standalone claims in particular context. I think you're creating more material, you're creating more opportunities potentially for standalone claims. Sometimes the follow-on picture isn't quite as clear, but certainly in the data and tech space, so much of it is standalone now anyway, and often it's not. When people talk about damages, I think they have a tendency to focus on downstream customers, but actually, things have changed, and a lot of the actions now, certainly in the tech space, are by competitors. And there are more and more consumer actions that are coming in, and that is also an area that I think is under enforced. And I think the DMCCA creates maybe, inevitably, if there's an SMS breach finding or something, it will create a basis for further potential claims. But I think the more important thing is almost the additional documentation, focus, interest, which itself may lead to standalone claims. And a particular example of that is obviously the consumer law piece, where you haven't got the direct class action option, but you've got the potential for findings to be made. Nature finds a way. I think a bit sort of Jurassic Park like. I think you're creating more of a corpus of findings, and you're giving guidance to the markets. And even if you don't go after a particular player within the DMCCA, certain findings may be portable. It's a bit like the railway tickets litigation. One of the cases that we won, the Gutman class action, essentially one of the questions was, is a failure to advertise a certain ticket type an infringement? Obviously, if you lose that case, then it could easily be portable to any number of other tickets that you say are not sufficiently well advertised. And I think it's similar here. People will watch the regime very carefully, and I think it will inevitably give rise to some additional options that weren't there for claimants in the past. But it's very early days, and that's beyond, obviously, I'm talking there about damages and infringements. You've obviously got the prospects of judicial review and challenges of fines and things like that that arise expressly under the regime.
And in your understanding of the design of competition law and policy, even, I would say, do you see private and public enforcement as going hand in hand, or there are some elements of zero sum where by putting a little bit more fuel into private enforcement, we somehow limit the discretionary power to use this powerful stick by CMA?
I don't think they always go hand in hand. I mean, obviously the public enforcement has got its own prioritization criteria, and there are different factors that need to be taken into account. And you could say that, there's quite a heavy political interference now when you look at the growth agenda and how that's, which I think is fair to say is probably resulted in a reduction of some types of investigation that might have taken place in the past when the OFT, as then was, for example, was much more aggressive under Fingleton, for example, and was willing to test cases and run things to appeal. I think at the moment, if it was left to public enforcement, there would probably be a lot of instances of genuine harm that are not challenged. And I think private enforcement has really opened the floodgates. And often, coming back to the competitor piece, I think people are seeing parallel complaints and standalone claims as part of tools to really put pressure on other companies. And that's worked for a number of parties. And, I think you've got quite a large litigation team within the CMA now. They're obviously entitled to various submissions in cases and have an automatic right to intervene. And they've intervened in a lot of different cases and made submissions on legal issues. I think there is a long-term question about the CMA's role in that type of litigation and how it ties in with its own priorities. I think speaking to CMA, legal team, they always want to say that they're, outcome neutral, but I find it difficult I find that that's a difficult word for me. I don't know how you put in a submission whilst being outcome neutral. You have to have some form of awareness. And I think we're in a bit of an unusual period at the moment, where obviously you've got the chance of a new prime minister now, maybe a change of direction. You've got a lot of new tools and instruments in the market. You've got a highly sophisticated authority in the CMA, but you've also got, a lot of companies who are willing to bypass it and go standalone. And I can't at the moment see the dynamic changing very much. I don't think increased DMCCA enforcement will lessen the standalone environment that we're seeing at the moment. I just think they have, even if they overlap a little bit, I just think they fulfill slightly different needs.
And more specific, a technical question perhaps, voluntary commitments. It's a kind of nuke, or it looks like not within the DMCCA, but is it the case that they can, if interpreted correctly, it gives the immunity kind of against private enforcement, or sufficient or a powerful trump card in the discussions in this regard? And if yes, does the can the CMA use it strategically by as a kind of an agreement with the designated undertakings, and in return receiving non-circumventing type of compliance with other probably more important aspects, more important for public enforcement? Do you see this bargaining mechanics, or it's too esoteric and just fantasy?
I think you've had, in the past, and some people from my firm were involved in creating it, you've had the ability during cartel investigations, for example, to make a voluntary offer, for resolution and then get a reduction off your fine. And I have to say, that it's a very good idea in principle, but the take up of that has been spectacularly poor. And I think that's partly because it doesn't insulate you from the damages risk. And I don't think voluntary commitments insulate you from the damages risk. Again, I would also mention the point that, the CMA has UK jurisdiction. People are bringing claims everywhere. The Netherlands, the standard Dutch claim has assignments from 20 plus jurisdictions. And there's nothing that's binding you on a cross-border basis. So the gate, coming back to the picture is global. The CMA is an important, but only one jurisdiction. And yes, a formal infringement finding would obviously be more difficult to defend, and certainly in terms of liability and the risk of more comments on effects and things like that. But is voluntary commitment to get out of jail cards, no. I think if people still think that there is something to be found there, or there are findings which point to an infringement, that I still think you've got a risk of standalones being brought, or other complaints being filed. So I don't risk in that respect significantly.
Even regardless of the fact that they precede any conduct requirements. So it's kind of in return for not introducing conduct requirements, these commitments voluntary commitments are taken. It doesn't change the situation much.
No, I don't think so. I think if I were a claimant looking at it, as I say, I prefer an infringement finding. And it depends on what your claim is based on. I mean, it could obviously, prevent your claim if your claim is mainly focused on conduct. Obviously, you can seek injunctive relief now, and you've got the possibilities of declaratory relief under the DMCCA, as alternatives. But I think even if conduct has changed, I might have a damages claim in respect to the previous conduct. In some ways, a recognition of a change in conduct would suggest that something was wrong in the past. And I think people will always look at that, and they'll scrutinize it. And as I say, yes, as a claimant, I think you're always going to prefer a hardcore infringement finding. But does it stop the risk that there was an infringement before? No. Some commitment decisions may even have findings about it being such horrid conduct before that you need these commitments now that in some ways facilitate the bringing of those claims for the historic conduct, even if things change from a forward-looking perspective. But it's I think it's a wait and see. I mean, it's to give some parallels as well. I mean, market studies have been used increasingly, and they're not always finding formal competition infringement, but claimants are looking at them increasingly, and irrespective of what the finding is, they're looking at the substance of the exchanges, and they're seeking disclosure, and they are it all feeds into an assessment of whether or not you're going to bring a claim or not.
Yeah, makes sense and explains a lot. I wanted maybe to ask you also about the composition of the cat, or the nature DNA of the cat, coming from kind of civil law jurisdictions where you would expect it being more crystallized, the judicial authority. Here we have in the UK the tribunal, which is being created in a more kind of hybrid way, bringing expertise from different sides of the profession, creating quite unique. Is it unique actually? And if it is, what are the main specificities and features of the system in your view?
I think it is. I think it is unique from a European perspective in that you have got a cross-disciplinary court in this way. I would say in continental Europe, you are seeing judges increasingly looking to rely on court-appointed experts, which you usually would get as an automatic point as part of the panel, but slightly different setup in terms of what they do on the continent. But I think it's I think it is unusual to have such a diverse range of panelists. They're not always economists. It could be accountants. It could be business professionals providing, or academics providing inputs to a case. And I think certainly in complex industries, whether it's tech or elsewhere, it allows the tribunal to, when used right, to get up to speed better and adds different perspectives, which I think can be helpful, and I think contributes to the CAP being probably the most sophisticated court of its type in Europe. Certainly, when you also take into account the fact that the judges are often specialist practitioners with many years of experience, rather than judging being a profession of its own, which you see in some countries. So I think it does create a particular dynamic that we don't really see as much in other tribunals, certainly in Europe.
And how important is the element of subjectivity in your view? Because they have different, not only professional background, but in some cases they have very different normative perspectives on these highly important issues, and thus the depending on who will be ultimately sitting in the panel may affect the outcomes.
No, I think that's certainly right. And you can obviously, even within a panel, have dissenting judgments. My former partners, Paul Lomas, I think dissented in in one of the first cases of dissent against Marcus Smith a couple of years ago. And there's the prospect of disagreement. They don't all have to agree on on every point. Of course, panel inclinations and makeup can vary and have an impact. I would say, again, perhaps unusually compared to other courts, obviously you have a president in the CAT, and in the history of the CAT, the president has had a lot of importance, and you can see the president wanting to be on the panel, or steer policy and discuss outcomes across cases, and you can see that play out. Most recently, there's been a particular focus on procedure, making things faster, making submissions shorter, shortening pleadings, lowering the cost. And that's coming out in some of the practice directions and CAT correspondence, but you can tell it's also being cascaded across the panels. So there is, I think, more of an exchange between panels and more direction, central direction, than you would get in some other jurisdictions as well.
A couple of approaching the last part of the conversation, a couple of questions which are more of socio-legal functioning character. When we look at these top tier law firms, obviously there are many. It's like in playing in Premier Leagues. There are many excellent professional football players, but only a handful of them do play in these top tournaments. So there must be something premium in terms of your qualification, in terms of your understanding of things. Is it possible to verbalize, to somehow classify these features, or again, everything is ad hoc? And the second part of the questions, don'ts, the mistakes which again are forgivable for most of normal mortal people, and they are taboo for the when you play these games.
Yeah. I mean, look, there are talented first-rate lawyers, I think, all over the city, and so it's not always, as with any recruitment decision, not everyone gets it right all the time as well. I would say, once you're in there in a place like ours, and I mean, obviously there's a recruitment process and there are certain requirements which set, particular thresholds. But then when you're in it, in terms of, the nature of my firm, certainly we just have so much experience, and, it's not just one jurisdiction, it's cross-disciplinary and it's international. And that sort of bank of data know-how, and that again, that sort of lack of cross-border fiction, used to working with each other and seeing the patterns globally, just means you have something that a lot of people don't have access to, and there are not that many players in the market who can deliver that global offering in the same way, certainly in sort of key markets that you see becoming increasingly important, the likes of the States, the Netherlands, Germany, UK, Spain, amongst many others. But I think ability to deliver cross-border in that sense is important. And again, it's not to say there aren't very smart people in other law firms, but I think it's that sort of package of being able to deliver that thinking in a collaborative way that really sets apart the best practitioners. And I think in terms of delivering that and no-nos and things like that, I do think it is when people get too insular and they don't see the bigger picture, and sometimes they can be focusing on the wrong thing because they want a very narrow victory, and maybe they could get a better outcome in certain instances, but then have a terrible impact on the broader business. And I think one has to stay humble and listen and not get too carried away with one's own ego or thirst for victory, and realize that you're in a service industry. Ultimately, you're acting for a client and doing the best job for them, and doing the best job means looking at their businesses as a whole and thinking about what the best advice might be. And sometimes that may mean that the best advice is to involve certain other competencies, or in my firm certain other partners or things like that. And I think not forgetting that sort of outlook, and I think generally making sure that you set up systems in a way that minimize risk. We've had other cases where people have missed case filings or appeal deadlines, not my firm, but others, because the volume has just been so great and they haven't had the systems to manage them. And so I think also the tech side of things, being in an era of excessive information, being able to manage and process that information in the best possible way is key.
But to continue with this visualization, you receive an important new case. Is it so? Your distinctive feature, your and similar caliber law firms, that you know the path, that you know the journey, you know the technicality, or there is also element of creativity, and there is no one single path, and you can co-create something new. What are the proportion of this? Knowing the technicalities versus being original and interpreting things which are taken for granted by most of us.
I mean, I would say this because I'm a creative, but I always think, and it might sound slightly arrogant, but I take some pride in looking at things and thinking I can see things others don't see. And sometimes that may not be the best argument, but I think if it was just, to your point about established practice and established, I think a lot of the cases are one on knowing the technical case law and the details obviously very well, but then being willing to push the boundaries and test things in the right way. And you can see those sort of debates taking place now. And I mean, I'm acting on the salmon certification cases, for example, and I was told going into that certification hearing that there was no way we were going to win and be successful. But I looked at the case, and I looked at the case in front of me, and just felt that it felt wrong in terms of how the claimants put the point, and actually there was enough in the case law to challenge them on costs and benefits in particular, and we ended up winning on that point. But if you over rely and you become too determine, but if you feel it's too predetermined by existing case law, then you could easily, you can easily step away from making those points. But it's always a risk assessment about how hard you push things and where you push, and what lines you take. And I think to be successful or get the big wins, you have to read the case, you have to understand the case, you need to understand the broader implications. As I say, sometimes something you as an academic may see as a loss is actually a win for the business. And it's knowing where those lines go for you and what is important for the business. But I think it is also being creative. But frankly, I think bringing people, I think about these things in terms of chess, and I live, 2 years, 3 years forward from now. I'm not thinking so much about tomorrow. I think about, if I do this, what's that going to, and I look at things in terms of that sort of flow chart. What's the impact going to be if I do this? And I think you have to bring clients and others along on that journey with you. So you essentially set out, how things can play out, what the options are. If you do this, that will happen. Our chances of success on this or that. So people have a sense of that journey. And then if you try something, people know what the potential outcomes are and what your chances are. And hopefully if it comes off, then, you're successful and people are happy. But even if you lose sometimes in those instances, if people are on that same journey with you and understand, what the risks are, then, it can still be a success to some degree.
Another question, AI 2026. We hear about the omnipresence, etc. But how do law firms use AI today?
I mean, there's a obviously as is the case in academia as well. I mean, I think there's it's obviously a significant debate about AI, and there are some big, law-related unicorns like, Harvey and Agora, which a lot of people in the market use. I mean, I think everyone in the market is interested in asking about it, and I think every law firm has to engage with it. Clients understandably want to know how you're using it, how that is going to increase efficiencies and save costs. On a flip side, from a case perspective, coming back to that lower threshold for bringing claims, I am on claims where, claimants are just generating letter after letter after letter using AI, and you still have to respond to them, even though bits of them are, gobbledygook. And it's also, I think, democratized that complaint status, because if I'm, a single person in a small supply chain and I type into Gemini, oh, I feel the supplier has overcharged me, draft me a letter making legal claims as to how I should respond. Sometimes you can get a pretty good outcome for that. And we have seen that in some cases, that you just, it's easy to send these things out now. And at the same time, to scrape if people make mistakes in their press communications or in judgments on a global basis. I think understanding engagement with AI is key. I mean, we've even seen, disclosure is obviously a big piece of a lot of litigation, more so in Anglo-Saxon countries, but it's coming in Europe. And, I had a recent case where one of the rationales given for requesting documents was to train the AI model. And, I still think there's a bit of a lack of awareness sometimes in the court system about how these models work and how they process things. But, it is an inevitable part of litigation and, competition cases going forward. Also, from a regulatory and authority perspective, I mean, your ability to monitor market conduct and to, identify behavior that looks odd has just increased significantly if you use AI tools. And also for businesses, I think, to monitor compliance and potential risk issues, there are a lot of powerful tools in the market that that impact that. I would say, there will be, it's still an evolving understanding of how these tools use, and they improve, like Gemini improved massively, over the course of about a year in terms of the results and the deliverables. But I think there will be an ongoing debate about when to use them, how to use them, and who bears the costs. Obviously, Sullivan and Cromwell and various others have got into trouble for submitting made up court references to courts, which, I think hallucination isn't going away. So you need to, have a handle on those practices, and the costs of a lot of these tools are going up, and who's going to pay for that, and how much the law firm's willing to, foot the bill for usage as usage fees go up. I think they're all live questions going forward.
With all this which have been highlighted today in this conversation, the speed with which the systems evolve, accessibility of information, and thus the need to comprehend, digest so much, and many other cacophonic kind of developments, what would be your recommendation to students? How would you select among many excellent graduates those who would be offered the job?
I think for me, obviously every law firm, has certain minimum academic requirements and things like that. But when I talk to my trainees and associates and the people, when I do interviews with potential recruits, there are a few things that come to mind. I think fundamentally we're a service industry, and I think a lot of lawyers forget that. In many ways, it's not different from being a restaurateur or providing other services. And lawyers have a tendency to put themselves on pedestals. But as I say to some of my associates, there are a lot of people in our building, for example, in the kitchens, the print room, the cleaners who come out late at night, who are often under more pressure and in more difficult situations than we are. And ultimately, we serve our clients. And on a micro level, you serve the people you're working with, both up and down. And I think the people who are successful, not just in the legal careers, but elsewhere, are the ones who remember that, and remember that it's important, how you make other people feel and whether you're looking out for them. It's not just about you. And I certainly think in terms of interactions with partners, some of the most successful associates and others are those who actually realize the partners are also human beings. And with the same thing with partners realizing clients are human beings. And I think it's that question when you go in, are people confident but service minded and realize we're in an industry where we need to deliver? Are they resilient? Because inevitably in these jobs you'll have days, especially when you're junior. I think it gets easier after about year two as an associate, just because you get used to things. How do you handle pressure? How do you deal with things? Do you fight back? How do you develop? Because I do think one of the areas for progress is volume to a degree, and how you handle that, and that changes over time. Are you sharp? Can you be concise in your thoughts? Can you put forward your views? And are you collaborative? Is it all about you, or can you work well with others? And how do you empower and influence a team? And I do think the most successful lawyers in the market, and I always look for this, are the ones who have an element of EQ. Obviously, IQ is important, but can you read a room? Can you read the people? Sometimes it's more important to read a judge than it is to get the right technical argument. What's going to work well with them? What's going to work well with your client? So that they're also, there are obviously a whole range of criteria. Nowadays, you also need to be very up on and able to understand tech. But personally, I would look more for a capacity to do that, and a capacity to learn quickly, a capacity to adapt, a willingness to work hard and progress, than somebody who is giving me too much sheen or has been overly trained. I want to know who the person is in front of me and whether they're authentic, and how I would feel about working with them on an ongoing basis.
On this occasion, I usually finish the interview, but I have one PS question, if I may.
Absolutely,
Um,
yeah.
n- Namely, the concept of legal privilege. When we look at psychiatrists or any medic or let's say priests, I can imagine that they know about human nature more than most of other people who are not privy to this information. Do you know more about, let's say, digital markets than when talking about with your clients about the nitty-gritty of things? Then, and do you know some pieces in this jigsaw puzzle which are really essential for our understanding of how the system functions, or it's not as decisive?
I think, look, I mean, I think everyone who's recruiting in the market and stuff like that will talk about tech competence, understandably, and there are different generations. And, there are cases I'm working on now in the tech space where I definitely didn't know everything about the markets before I started on them. And inevitably, when you start up, you have to learn. Nobody expects you to know everything about an industry, at the get-go, but you need to have a capacity to learn, because even if you think you are an expert on shopping, search, ad exchanges, buybacks, whatever it might be, I can guarantee you there will be several degrees of nuance beyond that. And I think one has to have a willingness to learn about industries and a base nowadays with students, a base technical understanding, a base ability to question AI results, a base ability to use computers and the right programs. I can remember once a junior associate told me I'm a lawyer, I don't do Excel. I thought, well, that's interesting because all my clients do Excel. So how are you going to be helpful to me? And it's that I think you have to have a base understanding of a lot of these products, but you don't necessarily need to be the world expert on them. And I think that will just accelerate. My 6-year-old is currently on a camp doing coding, and she's at 6 coded a game with some basic functionality, which is way beyond anything uh, I can do. So I mean, I think inevitably that base threshold for what is needed is will change and most likely increase over time.
And on this positive note, I propose to finish this conversation. Let me say most sincere thank you for your time and for sharing your ideas with us, Nicholas Frey.
No, thank you very much for your time as well, and thanks very much all. Cheers.